since I do both sides, I can speak to both sides. So as a plaintiff's lawyer, one thing I tell my clients from the beginning is I need to know everything. I need to know everything about the case. I need to know your deepest, darkest secrets. I also need to know who knows about this situation or who might be a potential witness that the other side would want to investigate. Also for plaintiffs, I investigate them as much as I can, putting myself in the shoes of the defense team, because we handle in my law firm high-stakes litigation. So usually we have well-funded defense lawyers on the other side who are not going to spare any expense. So they will do ordinary routine discovery of my client. They'll serve written discovery, they'll take a deposition. But they'll also search the internet. They'll potentially hire investigators. They'll talk to everybody that the client knows, including the client's mother-in-law, which is always a good source for unpleasant information. It's your mother-in-law. I'm joking, but they will do a very thorough job in official discovery, routine, formal discovery, and then they'll also investigate outside the discovery process. So as a plaintiff's lawyer, I need to know everything that I can about the client and the case. Everything the defense is going to get from me, obviously I'll give them, but I also need to know everything that they may get that my client isn't telling me about. On the defense side, of course, it's the opposite situation. You're the person who's defending. You're not the person who is on the offense. You're on the defense. And you'd like to produce as little as you possibly can as a defendant. You were dragged into this in your own mind. That's the way you look at it. And discovery is expensive and inconvenient. It is for both sides, but particularly it can be for large corporations. So the litigator has to be very firm on the defense side to insist that the defense client comply with all the discovery responsibilities, the rules, and the requests that are made. There's nothing worse than being a defendant who has not complied with discovery and the plaintiff's lawyer finds out. And then there's sanctions hearings, and there can be very draconian consequences, worse than what would happen in the lawsuit if the client doesn't comply with discovery. I represent a number of large corporations. I deal with executives, and I have to stand up to them sometimes, and the legal departments, and say, look, I know this is a pain in the butt. I know this is expensive. I know you want to get on with making the widgets or whatever your corporation does, but my job, and one of the reasons you've hired me, is to tell you it's tough love. It's tough love, and we have to comply with these discovery requests, and we have to be sure that we've produced everything in discovery that's being called for by the other side. But that can be quite a challenge with a sophisticated defense client to get them to comply with the discovery requests. So a client can lose a winnable case because of mistakes that the client can make. And sometimes it's by fearing, the client fears something that isn't there's no need to really fear that particular issue in the lawsuit at hand. And one of the things I tell my clients when they come in, and I've been retained, is you need to tell me, you need to trust me. And the attorney-client relationship, of course, is one of confidentiality, and so your secrets are safe with me. But you need to tell me everything in your life that you fear, that you dread that someone might know or that might come out. Because in a litigation posture, almost everything in your life is fair game in discovery. There are some things that a lawyer can keep out of the litigation context. But in the United States, we have very, very broad-reaching discovery, and a good lawyer on the other side can usually think of a way to make just about anything in somebody's life relevant to the lawsuit. So I tell clients, please tell me your deepest, darkest secret, because if you don't tell me your deepest, darkest secret, and we're in your deposition, and the lawyer on the other side asks you the question and something comes out that you haven't told me about, it can be a complete catastrophe. If you tell me what it is you fear, then oftentimes that's something that we can talk through that doesn't need to be, you don't need to be afraid of, that we can handle, that we can do damage control over. But when the client is exposed and the lawyer doesn't know it and is taken by surprise, then the client could make something a huge, big deal catastrophe which could have been controlled and contained if the client had told the lawyer, namely me, in the first place, and we could have dealt with it together. As a woman, it's interesting because I have clients that are men, and sometimes the things that male clients don't want to talk about, sometimes the things that men clients don't want to talk about have to do with personal relationships that they may not be particularly proud of or they don't want other people to know. So I have to actually address that issue and say, look, I'm not going to judge you. I frankly don't care what your personal life, what you do, but we need to discuss it and you need to be comfortable talking to me as a woman and telling me about those things, because otherwise I can't represent you to the capacity that I want to represent you. Trial lawyer, to be a good trial lawyer, has to prepare every case as if it were going to go to trial. Most cases settle. We don't try all the cases that we handle. Most cases settle, but the way to get a good settlement is to prepare that case as if you were going to trial, and that's the way to get the best settlement. But to prepare yourself to go into the courtroom and tell the story, you have to believe in the client and you have to believe in your case. If you don't believe in your case, there's probably something wrong with the case, and that's the time you need to tell the client, this is not a case we can try. This is a case that we have to settle one way or the other. If you're a plaintiff, sometimes you have to abandon a case because it's just not a case that can be won. If you're a defendant, sometimes you need to pay more money than the defendant might want to pay because they're bad facts. But for me to go in and try a case, go through the whole exercise, the whole drama of the courtroom, I have to believe in the case, and I do believe in the case. I believe in every case that I take to trial. That doesn't mean I always win them. That doesn't mean that I can always convince everybody else that I'm right. But for me, I have to believe in that case to walk into a courtroom and try the case.